There's a moth in here.
Oh, no.
About to stop. Oh, you're welcome. How did you close this, no?
Already, the attorneys are waiting. Y'all don't mind starting a couple of minutes early? Okay.
On me.
All right. Good afternoon. All right. Rose, can you go ahead and call court for us?
Court of Appeals for the 8th District of Texas is now in session.
Thank you. At this time, I will call case number 08-20-00157-CV. All right. If it aids in your presentation today, we have had an opportunity, obviously, to read your briefs, to discuss that with the court staff, and look at the record. So, and with that, I believe, Ms. Mathert, you may proceed.
Thank you, Chief Justice, and may it please the court. Records of a governmental body are subject to public disclosure upon request, unless those records are covered by an exception to the Public Information Act. Here, the University of Texas at Austin has invoked two separate exceptions that cover the records at issue. Section 114 is the aptly named student records exception, which of course covers student records. And Section 101 is the more general provision, often referred to as the confidential by law exception. With the court's permission, I will be spending the bulk of my time today on the student records exception. The student records exception is the exception on which the university moved for summary judgment below. And if the court is persuaded on the applicability of that exception here, then this court would reverse and render judgment for the university, obviating any need to address the more general confidential by law exception. What does the student records exception cover? Here, I would invite the court to follow along as I walk through the statutory language, which is reprinted in the handout that was provided to the court for purposes of oral argument. This is also a tab in our appendix to the brief as well. This is section 114. Subsection A of the student records exception defines the term student record. And I don't think we need to belabor the details of the definition, except to state that there is no dispute here that the records requested by Gatehouse Media are in fact student records. Moving on to subsection B, there are two sentences in subsection B. The first sentence states, information is confidential and accepted from the requirements of section 552.021 if it is information in a student record at an educational institution funded wholly or partly by state revenue. Here again, there is no dispute that the University of Texas at Austin is an educational institution covered by the statute, that the records requested are student records, and therefore I think even the plaintiff would concede that the university is entitled to withhold these records under the plain language of this first sentence of subsection B. Then we come to the second sentence of subsection B, and here's where we part ways with the plaintiff. The second sentence of subsection B states, this subsection does not prohibit the disclosure or provision of information included in an education record if the disclosure or provision is authorized by 20 USC 1232G or other federal law. The specific federal statute referenced here is the flagship federal statute in the area of student privacy, which applies to all educational institutions in the United States that receive federal funds. This is the family.
Just so I understand, your position is that, okay, FERPA doesn't prohibit the disclosure of the final results, but the first sentence then basically gives UT the sole discretion to decide whether it wants to give out that information or not.
I would quibble with that only, Your Honor, in the description of sole discretion. The university is governed by the Department of Education in its determinations that under FERPA. And so the university is not outside the bounds. The university is still supervised by the Department of Education in that regard. But yes, under the first sentence of subsection B, the university is entitled, these records are subject to an exception, and therefore the university is entitled to withhold those records. They could choose to release them, and this is under section 007, the voluntary disclosure provision. They could do that as long as they were willing to disclose it to anyone. So they could do voluntary disclosure, but they're also entitled to withhold under the specific student records exception.
And so I guess then that would explain why UTEP has decided to give the information out, but you take the position that the University of Texas does not want to give out the final results.
That's exactly right, Your Honor. And certainly, and we're not making any allegation that UTEP is outside the bounds. They're making a decision that they're permitted to make under the statute, as is the University of Texas at Austin. Both decisions are permitted under the statute. And that leads us right into that second sentence of subsection B, which states, which has this does not prohibit language. And I think that's exactly what Your Honor is getting at. So given that under the first sentence of subsection B, it's clearly subject to the exception, what does this language does not prohibit mean? And I think that's, plaintiffs are really trying to make something out of this phrase to try and turn it into something mandatory when it clearly is not. It is a permissive phrase, and it does not eradicate the entire exception by saying that somehow if we're not prohibited from releasing it, then we have to. And that's essentially what the plaintiffs are arguing. And what we're pointing out here, based on the plain language of the statute, is that it doesn't make sense. The language does not prohibit, the language does not require. And therefore that is the basis on which the university can make its determination that it will withhold under the statute that's permitted. And some universities may decide to disclose, that's also permitted. And I think when we talk about this language does not prohibit, I think really maybe the most generous reading of the plaintiff's position is that somehow there's something about the Public Information Act that maybe means somehow does not prohibit is supposed to mean require, because certainly if we read the language, it just says does not prohibit. Essentially what the plaintiffs are trying to do is get the court to rewrite it and say required. And is there anything about the Public Information Act that would lead the court to want to do something like that, to essentially rewrite the statute? And of course, what we would say is absolutely not. And there's several provisions we can point to in the Public Information Act that make it really clear that even this sort of generous interpretation of the plaintiff's argument doesn't really hang together either. So I would invite the court to look at 114C. This is the student records exception itself. C, the section right below B, what we've just been discussing, covers mandatory disclosure. It actually provides that a record covered by subsection B shall be made available in certain circumstances. And so here we can see that when the legislature wants to make a mandatory disclosure provision, it absolutely knows how to do so. It did it right in subsection C. They didn't use does not prohibit, they used shall be made available. So another section we can look to in this regard is 552.028. That is the inmate records provision. This is cited and discussed at some length in the briefs. 028 is a nice parallel, essentially, because it has the same kind of structure that we have in the student records exception. In 028, the inmate records exception, it starts out with subsection A, and it states that an institution or a penal institution is not required to respond to inmate requests. And then in B of section 028 dealing with inmate records, it states that an institution is also that the section does not prohibit an institution from providing the records. And so it's a nice parallel to what we have here. It's a not required and does not prohibit type situation. And what courts have said in the context of 028 is that the language does not prohibit clearly means not prohibited. It doesn't get magically transformed into some kind of mandatory requirement. And even in that particular line of cases, we've got cases cited in the briefs from the First Court, also from the Austin Court of Appeals, Waco, also Dallas. All those cases interpret that does not prohibit language in the same way to be permissive and not mandatory. And in the First Court of Appeals case, Moore versus Henry, which has the most extensive analysis, the court in that case found the meaning of does not prohibit so clear that the inmate's argument to the contrary, which is essentially what the plaintiffs are arguing here, the court found that argument frivolous. So here we have the same type of language interpreted in exactly the way that we're stating to the court that it's permissive and not mandatory. In addition, there's a couple of other sections of the act that the court can look to. The voluntary disclosure provision, this is 007. This is the provision of the statute that will allow a public body to disclose information, even if it is subject to an exception, as long as the information is not confidential. And if we consider that in conjunction with 352, which is the criminal penalties provision, it's at the back of the statute. It provides that a person commits an offense, which is defined as a misdemeanor, if the person distributes information considered confidential under the terms of this chapter. So what we can see from the voluntary disclosure provision and also from 352, the criminal penalties provision, is that yes, there is discretionary disclosure if the information is covered by an exception only, and there's mandatory withholding if the information is deemed confidential. And so what we can see there is that this is not simply an on-off switch as the plaintiffs are trying to get the court to accept.
If counsel, I could take you to another topic to make sure you have time to address it. And that's the 301, the 552-301. And the fact that the university did not ask for an OAG opinion. And so if we're going to look at plain text, like you ask us to on the construction of the statute, the plain text of 301 says that you must ask for a decision from the AG, and failing that, then there's this presumption that arises against you. And so I anticipate you're going to talk to me about AG opinions where the AG says, you know, we're not going to review unredacted information, but how would any of that ever overcome the plain text of the statute?
Certainly, Your Honor. So the text that we rely on here is, again, in the student records exception itself. It's 114D. 114D explicitly states that an educational institution may redact information covered under subsection B without requesting a decision from the Attorney General. So this phrase.
And I'll tell you what bothers me about that is it seems like you could have responded to the statesman and said, okay, look, here are these 79 cases. We'll tell you what the charge was and maybe what the disposition was, but we're going to redact the name. Or maybe you redact some other part of it that you think is personally identifiable information. But you didn't do that. I mean, you didn't give them anything. You just kind of told them to go pound sand. So how does D really apply here if you don't make a response where you've actually made a redaction?
Certainly, Your Honor. And I think the language of redact here is actually is broader in the public information context than withhold. So even though the statute says we can redact information covered under subsection B, that's the language, without requesting a decision from the Attorney General. And that does not create a duty to produce information in order to take advantage of D. Redact simply means that anytime you're disclosing information, even if the university were to make disclosures, the information that's covered by B can always be removed. So it wouldn't even have to be that the information requested would itself, in and of itself as a document, be a student record. That's how broad D is. It allows the university to take anything that constitutes a student record under this broad definition and take it out of anything that they produce. So in this case, if the state, and I don't even take the statesman to really be arguing this, that somehow if we had given them a blank sheet of paper, we would fall under D, because everything they asked for was a student record. That's why they asked for them. They were defined as student records essentially in the request. That's what they're asking for. So if we were to produce, if we were going to redact anything covered by subsection B, or essentially, if we were going to give them something, it would be a blank sheet of paper. And there's nothing under D that would require the university to do something like that in order to take advantage of the permission here under D explicitly to take out student record information without requesting a decision from the Attorney General. And so we're not going against the plain language of the statute. We're taking D at its word, which explicitly says without requesting a decision from the Attorney General. And there are other provisions of the statute, I don't know if I have those handy, but that also use similar language. So that, and that modifies that duty under 301 without requesting a decision from the Attorney General. So there's nothing, and in the plaintiff's briefs, I mean, there's really nothing that they propose that this could mean other than we don't have to request a decision from the Attorney General under the Act, which is clearly 301. So for D to have meaning at all, it means that we don't have to request a decision from the Attorney General when we are withholding information that's covered by B. And I think this idea about whether it should be redacted or not, there's nothing in the statute. It could have been written in such a way, maybe it could have said only if information is disclosed or something to that effect. That's not what the statute says. And redact is actually giving broader discretion to the university, no matter what it produces or doesn't produce. It can always take out student records. That's the legislative judgment that has been made about the sensitivity of these types of records. So I would just point out that we do rely on the plain language of subsection D. The other thing I would say about it is, even if the court were to disagree with us about D, that maybe for some reason we're wrong about the plain language of D, or somehow it doesn't apply the way that we think it does, that is not the end of this case. That does not result in a judgment for Gatehouse. All that does is put the university into a compelling reason standard. And for all the reasons we would discuss under the confidential by law exception, we go back to the trial court. We raised compelling reason. We alleged that we could meet the compelling reason standard. And so even if the court were to hold that somehow we should be held to that standard, essentially all that means is that the case gets remanded to the trial court so that we can go ahead and make our factual record on the compelling reason standard and demonstrate at trial that we could meet that standard.
In your argument, there is the Tyler versus Paxton case that I guess from the Austin Court of Appeals that put the burden on them for compelling is to disproving a compelling interest.
That's exactly right, Your Honor. And the other thing I would say, I'd be happy to submit this to the court in a subsequent letter brief. There was a decision from the Texas Supreme Court that came out on Friday, the Draugen versus Johnson case. And in that case, the court actually held that any presumption that would hold true at trial is immaterial to the movement's burden on summary judgment. So I would say, yes, Your Honor, Tyler versus Paxton, we've cited that in the briefs. We fit in the Tyler framework also because the Attorney General has held in the past that the fact that a record is a student record can in and of itself constitute a compelling reason to withhold. The Act itself in Section 305 also recognizes that the student records exception is one of a list of exceptions that deal with privacy concerns. And so we have raised those types of issues. We're in that same kind of box as Tyler versus Paxton. But I would also point the court to the language from Draugen versus Johnson just from Friday, where the court clearly holds that whatever presumptions may hold at trial are immaterial. That's the language the court uses, immaterial to the movement's burden on a traditional motion for summary judgment. And so the fact that we raised it as compelling reason, we said, okay, we don't think we fall into compelling reason. We think you're wrong about that. But even if you're right, we can meet the compelling reason standard. That case also demonstrates that unless Gatehouse can conclusively prove that we cannot meet the compelling reason standard, then they're not entitled to a traditional motion for summary judgment. And what the court, go ahead.
But how would they ever do that when you don't tell them anything about these 79 incidents? I mean, the 79 could be anywhere from date rape to somebody streaking across campus. And it seems like that would be important in deciding whether, there's a compelling interest in I guess your delay. That's what the focus is on, your delay in producing the material.
Right. And what I would say to that, Your Honor, is we did tell the trial court, if we're going to produce these records in camera, we should talk about them in depth as a factual matter. And here's the things we would have to do in order to do that. The plaintiffs just breezed right on by that and just said, we're entitled to judgment as a matter of law because, we filed the petition and we wrote the brief and we should be done. So we did argue for a fact-based determination. I would also say that what the Supreme Court's decision in Draugen versus Johnson said from Friday is that essentially if the movement is really trying to say that somehow there's not enough evidence on a point, or they don't know what the evidence is, or they can't think of what it might be, that's a no evidence motion. And that's what the Supreme Court really clarified on Friday is if you're moving on a traditional motion for summary judgment, you need to come and conclusively prove every element of your case. And if there's elements of your case that you can't do that because the other side has the information or there's some other issue there, and the court laid this out very clearly, that's what the no evidence motion is for. And that's not what happened here. Now, obviously, if we go back to the trial court, there may be additional motion practice, before a trial on the merits. So there would be additional opportunities to engage in that kind of motion practice. But right now, all that happened is that Gatehouse moved for a traditional motion for summary judgment, and they simply were not able to conclusively prove that we cannot demonstrate we fall within an exception and or that we could meet the compelling reason standard. We raised both of those things in our briefing and also in our initial disclosures. And I think the other thing I would mention about subsection D and the Attorney General's ruling is that not only did we argued based on D, the trial court actually found, even though the trial court found against us on the merits, the trial court thought that we were reasonable in interpreting D the way that we did, because this language without requesting a decision from the Attorney General is so explicit. We produced 22 Attorney General opinions, which cite subsection D. In addition to that, we did go to the Attorney General after the trial court expressed concerns that we hadn't done that in the first place. We went to the Attorney General and they gave us exactly the same kind of letter that we had told the trial court all along that we were going to get, which is a refusal to rule letter. And in that letter, the Attorney General stated that because the Department of Education has determined that educational agencies and institutions are in the best position to make determinations under FERPA, such agencies and institutions may withhold from public disclosure personally identifiable information in education records without the necessity of requesting an Attorney General decision. That's I believe that's tab 7 at the appendix. It's the letter we got, the refusal to rule letter that we got from the Attorney General. So I think whatever theoretical dispute we may have had with the plaintiffs about what would have happened had we gone to the Attorney General got solved when we went to the Attorney General. We've been right all along. The Attorney General said exactly what we thought they were going to say. They told us to go to the Department of Education if we had any questions. So, and of course they cited 114, and we have multiple other cases that also cite that language from D without requesting a decision from the Attorney General. And that has to, clearly that should be interpreted along with the language from 301. And if, with the court's permission, perhaps I will move at this point to the confidential by law exception.
You may not see it, but you're way over time.
Oh, my apologies, Your Honor. I will reserve the rest of my time for rebuttal.
Thank you for that. Thank you, Judge. And in the interest of fairness, Mr. Tumlinson will afford you that extra time that we gave Ms. Mather.
I appreciate it. I hope I don't need it, Judge. May it please the court.
You may.
The statesman brought this case under the Public Information Act for one reason. That was to uncover records that have been unlawfully hidden from the public by the university, that's showing students who were charged with sexual assault by university, who were expelled and who immediately transferred to another university to participate in intercollegiate athletics. The trial court here quickly recognized the university's violation of the TPA, and it's its order of disclosure that we would ask the court to affirm, although we are also the cross appellant, so we do ask for some relief from that judgment. I'd like to say a couple things. First, I'm going to try, there's a lot of briefing here. There's a lot of law. I'm going to try to distill this down to 3 major points why the court can affirm the judgment. And then if I have time, I'll try to talk about the cross point about the attorney's fees and costs. First off, I do want to say that I disagree once with the university. Even if they were right under point 114, and we're going to tell you why that's not right. But even if they're right under that, the court decided this under 301. You had your shot, you didn't take care of it. You're out on summary judgment, you have to disclose this. Whether or not you had a legitimate complaint under the exception, you still have to disclose. And one of the Attorney General's opinion that we cite in the brief, I believe it was OR 2019-25024, is somewhat similar. The university went to the AG, said we're, among other things, we're asserting point 114, and we want you to tell us whether we have to do this, but it wasn't timely, and they didn't produce the records for the AG to look at that they could look at. And what the AG said is you're out under 302. You have to produce it. If you have an issue with that, you're going to have to take it up with the trial court. So we can decide this under 301. And I think there's a real easy way to do this. And I have to admit, I have not seen the case that opposing counsel is discussing. It doesn't sound like it's a Public Information Act case, and maybe she can fill us in on that. And I'd be happy to brief anything on that after the fact. But I will tell you that we do have a Public Information Act case that talks about the compelling reason standard, and that was Paxton versus the City of Dallas. And in that case, the Supreme Court indicated that the governmental body had the burden. So let's talk a little bit about 301 and why the judgment can be affirmed just on that. We've learned from case law that the requester of information has to do a couple things. They have to request it in a written request, it has to be denied, and there has to be no previous determination on whether this information is accepted under the Public Information Act. We did that, and the last piece is the governmental body had to not request the Attorney General's opinion, and that's exactly what happened here. So we met our presumption, and we've got case law cited in the briefs that talk about what that is and the part that we have to meet. And now we do have that Tyler versus Paxton case. The only problem with that is we have earlier precedent out of the Third Court of Appeals that comes out the other way. It says that once we met our burden that I just described there, the governmental body has to meet their burden in terms of the compelling reason. The only way that the third court could overturn that under their own precedent, because they follow stare decisis, is they would have to overturn it. The interesting thing about that case is it doesn't discuss the earlier cases. There's also cases out of the Texas Supreme Court that talk about the same thing. There are cases out of other courts. And then after that was decided, there's this Paxson versus City of Dallas, which of course is another source of mandatory law, the Texas Supreme Court. So it's interesting that they don't talk about this. If they meant to overturn the earlier decision, they don't talk about it. That none of the cases that are cited that are on point are talked about in that. So all I can think of is maybe the practitioners didn't bring it up to the court, and for some reason it just had gotten missed. So that case is an outlier, and I'd also say that its import is diminished by the fact that the Court of Appeals has already decided this before and has to follow that decision, and by the fact that the Texas Supreme Court has too. Now they had a burden in summary judgment, and they had a burden to show that they had a compelling reason. We found out from Paxson and City of Dallas that there's a little bit of a test involved with that, and the test is it's reason to withhold is compelling only when it is of such a pressing nature that outweighs the interests of favoring public access. So that's the test. The university didn't discuss it. In fact, their position in the trial court was, we just didn't have to request the opinion. So at no point in the trial court did the university supply a compelling reason. And at no point in the trial court did it discuss the test from City of Paxson versus City of Dallas. And if you go back to the briefing, do they apply the test? Do they say that there's a compelling reason to apply the test? They don't. They still don't. So the consequence of this, and this is what the trial court decided or indicated it decided, was that the university has to now disclose the information, and it's over at that point. And you can see that. I don't want to go through every AG opinion, but they're cited in there. You can see that that's what happens when you don't comply with 301, is you get the effect of 302. So even if they come back now and somehow prove that 114 applied, it's too late. They're out. They have to go ahead and disclose this information. So that's the easiest way for this court to affirm the trial court's judgment. The second easiest way is I'll just really narrow down on the issues. The big argument by the university is that they have discretion here to, if FERPA permits its disclosure, they have some discretion in disclosing the information. This is contrary to a number of attorney general opinions that we cite, and some other sources of law out there too. But we've got plenty of attorney general opinions that say that if it's permitted by FERPA, then you have to disclose it. In none of those opinions do they say that you have discretion. They tell the university, the state-funded university, that you have to disclose. Let's pretend that didn't exist. Let's just pretend that didn't exist. The other problem with the argument is that the university wants to view certain language in the PIA in sort of a vacuum. And part of that is, of course they do, because they don't want to disclose the information here. But you can't read it in a vacuum. We all know that. And I don't want to get too deeply into the statutory construction canons out there. We're all well versed in those. But if you read it the way they read it, it makes the second line of B superfluous. Now, maybe you make an argument that if you just look at B altogether, maybe there's an argument there, but it's not just B. There's D, which thinks about these situations where there's times that you're going to be disclosing something that you redacted, but there's also the mandatory nature of the PIA, and you have 522.026, which states this chapter does not require the release of information contained in education records of an educational agency or institution except in conformity with FERPA. So that's one way to read it. And if you just change the words, but it means the same thing, is that you have to disclose if it's permitted by FERPA. So you've got the PIA, which works in a mandatory manner here. So you either have to disclose or not. Now, once again, if the university were correct with their permissive reading, then the AG would be telling all these state-funded universities under similar circumstances that seek their opinion that they have permission under their discretion to decide whether to release something or not. But they don't. It comes out the exact opposite. So you can't view the statute in a vacuum just when looking at the language, and you definitely can't view it in the statute when looking at other authority. Now,
if I could interrupt you, what's the rationale of those AG opinions? I mean, obviously, the Texas Supreme Court has disagreed with the AG on some of its opinions, and the AG opinions are, I guess, only persuasive to us. But what is the rationale that the university has no independent discretion on how it's going to administer the student records?
Well, they don't. They don't explain it, Your Honor. It's not. If you read the AG opinion, you'll see they don't explain it, but it's the way they treat it that it is mandatory. They tell the universities, and a lot of these opinions, honestly, that I've cited actually have to do with Texas Tech. But they tell the university that it is mandatory, and it makes sense because the PIA is set up. Now, not all of it is, and that kind of gets me into the point a little bit about the .028 in that language. Certain parts of the rights to access part of the PIA. In fact, this one that was talked about in Moore versus Henry about inmates, it says specifically in the language you don't have to disclose, right? But under our section, which is .021, and the way the PIA works, you do have to disclose. And I know that this gets said a lot in arguments and briefing, but the PIA specifically says that you need to liberally construct it in order to find that information should be disclosed. It also said any exception has to be narrowly construed. Now, if we go back to the university's reading in .114 and we apply those, right, and that doesn't win the day. That kind of language doesn't win the day. We all know that. But if you apply those, you will see, well, the university is really, to get where they need to be when you look at the totality of the PIA, the other sections that we discussed, and opinions out there by it, the only way you can get there is if you look at it sort of, as I said, in this sort of vacuum, right? Is the only way you could do it. But we can't do that. And the reason why that I think you see that, to sort of tie it back in, Your Honor, I think the reason why you see the AG come out that way is because they also know the same thing, that you can't just view certain sections of the PIA or any statute in a vacuum. You have to read them the way that they're written. You can't add language, and you can't make other parts meaningless or superfluous. And I think that's why you see the Attorney General come out that way. This case would be really easy if there were a court opinion out there that dealt with this exact situation. And let's say we were just arguing about .114, then we can determine this very easily. Now, if the court wants to decide this and go into that part of it, the court's going to have to do some statutory interpretation, and the court's going to come out with an opinion, which will be sort of the first of its vintage. But my point is that we don't need to go there. And even if you did go there, you should still affirm this based on 301 and 302. They had a burden. They didn't try to meet that burden, and they didn't even try to meet that burden later on, although it would be too late at the appellate stage. They still haven't given us a compelling reason. I want to briefly, if I can, pivot to 101, which was the other one. And you still run into the same problem with 101, is if we're right on the 301 and the trial court's right on the 301, 101 doesn't matter either, right, as an exception. Now, the universities seem to focus a lot on the common law privacy, so I'll focus most of my attention on that too. The first part is obviously it's confidential by law, either constitutional law or it can be common law also. Constitutional law, when they talk about constitutional privacy, that's sort of zones of privacy, and it's been pretty well defined what those zones are. And I don't want to get too far into that, have that in the briefing, but this doesn't fall into one of those zones. And I don't believe the university has really argued seriously about that. The university has taken the position that under the common law privacy standard, where there are two prongs to it, one is the of legitimate concern to the public prong, and the other is the highly intimate and embarrassing prong. The university has really sort of focused their attention on the first part of it to show how it would be highly embarrassing. And we make arguments about there's a lot of case law out there that's similar. It doesn't have to do with disciplinary records, but courts have held that that prong isn't met when somebody simply accuses somebody of criminal activity that's just out in the public. But I don't even think we need to get there. And I want to make this simple for you. If the court decided this on 101, it only has to decide that we conclusively disproved one of the prongs, and that would be that's not of legitimate public concern. You've heard probably the newsworthy defense or newsworthiness, and that's where this sort of comes in at least. There is a lot of case law out there that shows that the kind of information that we're looking for, and that's one thing to keep in mind, is I know that the university wants to make it seem like we want the entire disciplinary files here, but the court need look no further than what we requested, and that's all we want. You know, they can give it, they can take things out that aren't part of this request, they can redact, they can do whatever. And honestly, they could have done that. And when they sought the AG's opinion in a timely manner, they could do that. In fact, that one opinion I talked about, the AG scolded the university because they didn't submit information for review. Now, the AG is not in a position where it can make FERPA determinations. You've already heard the university talk about FERPA determinations. I just want to make clear there are no FERPA determinations made here. We all agree that FERPA permits the kind of information that we're looking for. At least we all did in the trial court.
In that regard, Counselor, can I ask you, your actual request asked for the violations committed, the institutional rules, and then somebody put a conjunction in there and said, and any essential findings supporting the institution's conclusions that the violations was committed. I'm not really sure I know what that means. When I say your findings, I think of like findings of fact that, and if they were sufficiently detailed, they might reveal the identity of the victim if it's sort of like a date rape type case. And so I'm just wondering if you would disclaim your intent to ask for any information really beyond the offense committed.
Just any factual findings that the violation was committed. We're not asking for any names. We would have said so. The only name that we asked for is the name of the student, and that's obviously permitted under FERPA.
Okay, but you understand, I mean, the factual findings could lead people to understand who the victim was if they were sufficiently detailed.
Well, I would say we'd have to speculate at this point. Remember, all we can decide in this case is what we have in the record and what we have in the summary judgment record, in fact, when we're talking about this issue. So we could talk about this all day, but we'd have to talk about it in terms of a hypothetical, and I think that that's not going to have any bearing on this case. If that's what the university wanted to argue, then the university should have got they could have gotten the records to the judge in camera, would be maybe one workaround here. They could have redacted what they thought and sent it into the AG, might be another. But we'd have to purely speculate, and you can't decide this case based on speculation. The university had its shot to do this, but right now all we can do is guess at what's in there because that's not part of the record. Okay, I'd like to, if the judge doesn't have a follow-up, Your Honor, okay. I'd like to go ahead and maybe talk about first that Moore case a little bit. And the reason why I want to talk about it some is that we've discussed it here previously. It's the type of thing that we see sometimes, and it's not a bad opinion, and other courts follow it. You've seen a lot. In fact, we went ahead and cited one from the Third Court of Appeals that follows it too. But I want the court, when you're looking at this, I want you to go a little deeper into it. Look at the type of analysis that was done in the Moore opinion. It was just assumed. There really was no analysis about the prohibiting language. But also you have to look at where it is in the PIA and what the right of access is. Inmates typically have less rights than the general public. That is just part of the system. And so I'd like the court to look a little deeper there and give that a chance. And honestly, there's a couple of cases like that too. Now, the other piece is they got into needing to establish a factual record. I believe it was under under 101. Once again, the court can avoid, even if the court wants to decide that issue, they can decide it based on the newsworthiness prong and not even have to get into that part of it. And I think I explained this in the brief pretty well. Looks like I got a couple of more minutes. I know the court gave me some more, but I don't want to take up too much of the court's time. I'd like to jump into, put my hat on as the cross appellant now and just talk about the attorney's fees and cost issue a little bit. We're asking that the court affirm the judgment, most of it. We're asking the court just to reverse the part of it where the trial court denied the fees and costs. And there's one simple reason for it, frankly, is that the statute is very clear that this is mandatory unless the governmental body reasonably relies on its 3 enumerated categories, and they're very clear. It's a published appellate opinion, it's a judicial court order that's applicable, or it's a written attorney general opinion. There's just 3. There's no more. There's no language suggesting that there's more. The court here didn't just indicate, the court said in communication with us that it decided it because it thought the university had reasonably relied on a plausible interpretation of a statute. That would work if there were a 4th category under the statute that said plausible interpretations of statutes or statute relying on statutes. I think the court would be in firm ground there, but because that is not in the statute, the trial court had to effectively write that in as the 4th category. So we think the trial court abused its discretion by doing so. But even if it didn't tell us that, even if we didn't know that, if you take a deeper look at the university's cited cases, cited AG opinions, and the authority that it relied, say it reasonably relied on, you're talking about FERPA determination cases, violation of FERPA cases that neither occurred here. You're talking about things that don't really have anything to do with this other than, they talk about FERPA. The other side also accuses us of saying, well, they need to be, they need to have cited things that are on point to satisfy that. Well, reasonable reliance obviously implies that there has to be reliance and it has to be reasonable. Now, if I just cited you a case that had to do with the DTPA and said, well, I relied on this one, well, that reliance wouldn't be reasonable, right? Now, I don't think they have to necessarily be on point, but I don't think the court has to decide that, because if it just looks at the cases, it will see that the university couldn't reasonably rely on it to get to the position that it was taking, that it didn't have to disclose. And especially under 301 and 302, because those we're not even talking about the exceptions. We're just talking about part of the statute that says, hey, you have to disclose this if you don't ask for our opinion in a timely manner and other circumstances haven't occurred. So, I think that the court can, and the court has, I believe I cited a case where the court can go ahead and render the fees and costs if it decides in our favor that the trial court should have. The information's all in there. It's pure, it's direct, it's clear. The other side has been nice enough to say, well, if you do come out that way, they think it's okay that you go ahead and render us our fees and costs. So just, in terms of judicial efficiency, and honestly, this has been some expensive litigation at this point, as you can probably see from the record. And so if the court does say that the trial court needed to, then we would ask that the court go ahead and render us our fees as we've asked for in there. Now, if the court doesn't have any more questions, I'd like to go ahead and end.
No, I don't believe so. Thank you so much. Rebuttal?
Your Honor. I want to go straight to this idea that Section 301 of the Act can end the litigation, or that somehow we don't need to go any further. The plain reading of that section of the statute is not going to support that analysis. All that 301 indicates is that if in fact we're wrong about D, that we should have gone to the Attorney General within the 10 business days to request a decision, and the fact that we went to the Attorney General but just not in 10 days is somehow not enough. If all that is true and we end up in this scenario where we need to show at trial a compelling reason for withholding. And to listen to plaintiff's counsel, you would think they moved for a no evidence motion for summary judgment. They did not. That was not the basis that they moved on. They moved for a traditional motion for summary judgment. They took the burden on themselves to meet the standard for a traditional motion for summary judgment. And when they did that, their job is to conclusively prove that they are entitled to the records. And here is what they said with respect to the 101 exception. So they had all this argument, and then they said, okay, with respect to 101, because of course we had raised it, they knew it was coming, and in their traditional motion for summary judgment, which they chose the timing of, with respect to 101, they said this: the statesman is aware of no other law other than FERPA that would permit withholding. That's it. That's what they said. We're aware of no other law. And whatever it means for a summary judgment movement to conclusively prove all essential elements of their case, this is not it. Just throwing up your hands and saying, I can't think of anything, does not entitle anybody to a summary judgment. And here again, I think just emphasizing that just last Friday, and I'm happy to provide the citation in a short follow-up to the court of Draugen, I hope I'm pronouncing that correctly, versus Johnson, the court was crystal clear that the fact that a presumption may arise at trial is immaterial. That's the word the court uses, immaterial to the movement's burden on a motion for summary judgment. So the fact that 301 might create a presumption if we didn't correctly navigate the request for an attorney general decision does not end the case in the slightest. It simply puts us into the compelling reason bucket. And if Gatehouse wants to, on remand, they can file a no evidence motion for summary judgment. They're the plaintiff, they're in charge of how to run their case, but that's not what they did here. And they don't get to just turn it into one because now they realize, well, we didn't really put in anything. What they said was, the statesman is aware of no other law other than FERPA that would permit withholding. That's what they said in their motion. And that doesn't even, so under traditional standards of a motion for summary judgment, that's not even going to require a response from the university. Now, of course, we did respond and we raised fact issues and we put in affidavits and so forth, and all of that's in the record. But even if we'd done none of that, they would still not be entitled to a motion for summary judgment simply by saying we're not aware of anything that counts. So this idea of 301 simply resolving the case and not having to address any other issues simply does not match up with the standards for summary judgment that are laid out clearly in cases from the Texas Supreme Court and from the Third Court and certainly from this court as well. With respect to the 101 exception, the plaintiff did highlight these two prongs, whether disclosure would be highly objectionable to a reasonable person and whether the disclosure would be the term they use is newsworthy. What the court actually, the term in the cases is not of legitimate, is whether it's of legitimate public concern. We raised a fact issue on both those points, and that's very clear from a reading of University of Texas versus Paxton case from the Third Court that we cited, which is completely on all fours with this case. And you can tell that because the plaintiff's response is basically, well, it must be wrongly decided because there's simply no way to apply University of Texas versus Paxton and come out by affirming this judgment. It's a straight reversal based on the rationale of that case. What the Third Court did in University of Texas versus Paxton was it went through this analysis and said, first of all, that it is the movement's burden on a traditional motion for summary judgment to show entitlement to judgment as a matter of law. And the court held in that case that simply asserting that the other side can't meet 101 doesn't count, which is exactly what the plaintiffs did here. And then in addition, the court found that the university had raised an adequate fact issue because the university had introduced some very cursory details about the study, and they had also demonstrated that there was a promise of confidentiality or asserting confidentiality that was provided to the participants of there was a a study in that case, a social science study that was at issue. So we're completely on all fours with that. We have essentially what I hear the plaintiff saying is, we did raise a fact issue on this first prong of highly offensive to a reasonable person. They were essentially not discussing that. They're saying, okay, well, maybe we win on the second prong. We also raised a fact issue on that prong, because what we said was, look, here we introduced the university's rules for student conduct examinations of the type they're asking about. And the rules clearly state that it's not the same as a criminal trial. We also introduced case law, which demonstrates that other courts of appeals, the Sixth Circuit on the federal side, held that there were significant differences between a student disciplinary proceeding and a criminal proceeding. So we absolutely raised a fact issue on that point. And there's no question at all that even if somehow what they said on 101 is deemed sufficient, not aware of any other law, even if we get past that, even if we go into, well, okay, what was the university's burden to respond to? The only thing we have to do is show a fact issue. That's it to warrant reversal and remand to the trial court so that we can have a trial on the merits. And we've raised that fact issue certainly by the two affidavits that we introduced, and those are at tabs 10 and 11 of the briefs, and they also attach the student records, the confidentiality promises that are provided to the participants, and so forth. I also just wanted to say, I think it's certainly interesting that even in response to the court's direct question, the plaintiff will not disclaim they're going outside of the language that's permitted by FERPA. They essentially said, no, we're not going to disclaim that. They're going to stick with their request to have not only names and what is actually permitted for the university to disclose under FERPA, but they're also going to go for this factual findings, which, as we did introduce evidence of in the trial court, there are, as Your Honor was pointing out, there certainly are dangers that would reveal the names of the victim. And that's exactly what the court was concerned about in the Morales case, which we also discuss in the briefs. Those are precisely, so I'm sorry.
Was that raised as a specific issue below, the fact that the request exceeded what FERPA allowed?
Yes, we did reference that in the briefs. That was not the focus of the argument, but we did raise that in the briefs that the language of they kept saying that they tracked the language of FERPA, and they clearly don't. They have this factual findings that's not anywhere in the FERPA exception. So we did point that out. That was not the focus of the arguments, but we did point it out. We mentioned it also in the appellate briefs as well. And certainly the expectation would be that on a remand in a more fact-intensive analysis of these records, of course, we would provide the records in camera to the court as long as all proper protocols are preserved under FERPA so that we can do that. And then the records can be analyzed and determined whether all the things that they requested, either whether we are or are not authorized under FERPA to release them, if we were to choose to do so, and what kinds of privacy concerns are raised by those particular facts and circumstances. That would, as Your Honor says, there could be, certainly a wide range of activities that would be encompassed within the request. And but I do think it's telling that they're not even willing to simply go with what is actually written into the FERPA statute. And they know that we raised a fact issue as to victim identities and so forth, because that was specifically referenced. I'm not remembering if it was the Davis or the Leary affidavit, but it was one of those that specifically discussed that possibility. So I guess what I would say and wrap up, Your Honor, is that yes, we have met our burden to create a fact issue, even though we don't have to meet it, because there's no way that what they produced was sufficient to conclusively prove that they were entitled to judgment as a matter of law. And with respect to the student records exception, again, that was our motion for summary judgment below. And our arguments are that as a matter of law, based on the plain language of the statute, we fall directly within the student records exception, and under D, we're not required to show compelling reason. And therefore, as a matter of law, we're entitled to a reversal and a render of judgment.
All right, thank you, counsel. We appreciate your participation and excellent argument today. The case will be submitted based on the briefs and your record and your oral presentations. So thank you again. We appreciate it.
Thank you.
Thank you, Your Honor.